If you filed a Form I-130 petition for a family member or you're planning to file one soon, there's critical information you need to hear today. The United States Citizenship and Immigration Services has officially confirmed a significant change to how they will process Form I-130 petitions starting in 2026. This isn't speculation. This isn't rumor. This is confirmed policy that will affect thousands of immigrant families across the country. The question many of you are asking right now is simple. What does this mean for my case? What does this mean for my family? Whether you're a U.S. citizen who recently filed for your spouse, a green card holder waiting to bring your children to America, or someone who's been stuck in the system for years wondering when your turn will come, this change will impact you. The good news is that understanding this change now gives you the opportunity to take informed action. The challenge is that many families don't yet understand what's actually changing, why it's changing, and most importantly, what they can do about it. Over the next several minutes, we're going to break down exactly what USCIS has announced, who will be affected, and what reasonable steps families should consider taking. No panic, no misinformation, just clear, professional analysis of what this policy change means for real families. Let's get into it. Before we discuss the changes, let's make sure everyone understands what Form I-130 actually is and why it matters so much to immigrant families. Form I-130, officially called the Petition for Alien Relative, is the first critical step in the family-based immigration process. It's the form that U.S. citizens and lawful permanent residents file to establish the qualifying relationship with a family member who wants to immigrate to the United States. Think of the I-130 as the foundation of the entire process. Without an approved I-130, your family member generally cannot move forward with getting a green card through family sponsorship. Now, who can file this form? U.S. citizens can petition for their spouses, parents, children, both married and unmarried, and siblings. Lawful permanent residents, commonly known as green card holders, have more limited options. They can petition for their spouses and unmarried children only. Here's where it gets important to understand the difference between two major categories. The first category is called immediate relatives. This includes spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens who are at least 21 years old. These cases are considered high priority because there's no annual limit on how many people can immigrate through these relationships. The second category is called family preference categories. This includes adult children of U.S. citizens, siblings of U.S. citizens, and all relationships involving green card holders as petitioners. These cases face annual numerical limits, which means even after approval, beneficiaries often wait years for a visa to become available. Why does processing order matter more than approval speed? Because USCIS processes thousands of I-130 petitions every month. The order in which they choose to work on these cases determines who gets reviewed first, who gets approved first, and ultimately who can move forward with their immigration journey sooner. Up until now, USCIS has followed one approach. Starting in 2026, they're shifting to a different system. Let's talk about what's actually changing and what's staying the same. For years, USCIS has generally processed I-130 petitions in the order they were received, with some internal flexibility based on workload distribution across different service centers. This is often referred to as first-in first-out processing, though it was never perfectly rigid. Under the old system, if you filed your I-130 in January and someone else filed an identical type of petition in March, yours would typically be processed before theirs, assuming both went to the same service center and had similar circumstances. Starting in 2026, USCIS is implementing a new processing order that prioritizes certain categories of I-130 petitions over others, regardless of when they were filed. Here's how the new priority order works. First priority goes to immediate relative petitions filed by U.S. citizens. This means spouses of U.S. citizens, parents of U.S. citizens, and unmarried children under 21 of U.S. citizens will be processed ahead of other categories. Second priority goes to family preference category cases, which includes adult children of U.S. citizens, siblings of U.S. citizens, and cases filed by lawful permanent residents for their family members. Within each priority level, USCIS will still generally process cases in the order received. But the key change is that all immediate relative cases will be worked on before moving to family preference cases. What does processing order actually mean? It means this is the sequence in which USCIS officers will pull cases from their queue to review, adjudicate, and make decisions. It does not guarantee approval. It does not change eligibility requirements. It simply determines which cases get looked at first. This is different from a priority date, which determines when a visa number becomes available for family preference cases. Your priority date remains the date your I-130 was properly filed, and that doesn't change under this new system. The new processing order also doesn't affect cases that are already with the National Visa Center or at consular post abroad. Those stages of the process follow their own procedures. USCIS doesn't make policy changes in a vacuum. There are specific reasons behind this shift in processing order, and understanding those reasons helps families make sense of what's happening. The first reason is workload balancing. USCIS service centers handle enormous volumes of cases. By establishing clear processing priorities, the agency can allocate resources more efficiently and ensure officers are working on cases in a systematic way rather than spreading efforts too thin across all categories simultaneously. The second reason relates to backlog reduction. Immediate relative cases don't face visa number limitations, which means once the I-130 is approved, those families can move forward more quickly through the rest of the process. By prioritizing these cases, USCIS aims to move families through the system without creating bottlenecks at later stages. Third, there's the family reunification priority. U.S. immigration law has always placed special emphasis on immediate family unity. Processing immediate relatives first aligns with this long-standing principle that keeping nuclear families together is a core objective of the immigration system. Fourth, national interest and efficiency considerations. When USCIS can process cases that will result in faster overall completion of the immigration process, it reduces administrative burden, minimizes pending case loads, and allows families to reunite sooner rather than having cases sit in various stages of incompletion. These aren't arbitrary decisions. They reflect USCIS's assessment of how to manage a complex system with limited resources while trying to serve the most people as effectively as possible. That said, every policy change creates winners and losers, and this one is no exception. Let's break down who will see benefits from this change and who may experience longer wait times. U.S. citizens filing for spouses. If you're a U.S. citizen who has filed or will file an I-130 for your husband or wife, this change works in your favor. Your case will be in the highest priority category. This means your petition should be reviewed and adjudicated ahead of other categories, potentially reducing your overall processing time. Green card holders filing for spouses. If you're a lawful permanent resident filing for your spouse, your case falls into the family preference category, specifically F2A. Under the new system, your petition will be processed after immediate relative cases. This doesn't mean your case won't be approved, but it may take longer to reach an officer's desk compared to cases filed by U.S. citizens for their spouses. Parents of U.S. citizens. Parents being petitioned by their U.S. citizen children who are at least 21 years old fall into the immediate relative category. These cases will receive first-tier priority processing, which is beneficial for families trying to bring elderly parents to the United States. Unmarried children under 21. Children under 21 being petitioned by U.S. citizen parents are also immediate relatives. These cases get priority processing. However, families need to be extremely careful about aging out. If a child turns 21 before the case is fully processed, they can lose immediate relative status and convert to a family preference category, which creates significant delays. Adult children and siblings. Adult children of U.S. citizens fall into preference categories F1 for unmarried and F3 for married. Siblings of U.S. citizens fall into F4. All of these cases will be processed with lower priority than immediate relative cases. For families who filed expecting first-in first-out processing, this change may extend how long it takes before their petition is reviewed. Additionally, these categories already face extremely long visa bulletin wait times measured in years or even decades depending on country of origin. The processing order change adds another layer of potential delay before the I-130 itself is even approved. The bottom line is clear. If you're petitioning an immediate relative as a U.S. citizen, this change likely helps you. If you're a green card holder or petitioning adult children or siblings, you may experience longer processing times than you would have under the old system. One of the most common questions families are asking is, what happens to my case if I already filed? Let's address this carefully. Cases filed before 2026. If you filed your I-130 before the new processing order takes effect, your case doesn't disappear and doesn't get cancelled. It remains in the queue. However, when USCIS implements the new priority system, your case will be categorized based on what type of relationship it involves. If your pending case is an immediate relative petition, it will be moved to the front of the processing queue along with other immediate relative cases. If your pending case is a family preference petition, it will remain in line but behind immediate relative cases that may have been filed more recently. Your receipt date and priority date do not change. Those dates remain exactly as they were when you originally filed. Cases filed in 2026 and later, any I-130 petition filed after the new system takes effect will be subject to the new processing order from day one. Immediate relative petitions will enter the highest priority queue. Family preference petitions will enter the secondary queue. Does priority date change? No. Your priority date is established when your I-130 is properly filed and remains unchanged regardless of processing order. For family preference cases, your priority date is what determines when you can move forward once a visa number becomes available. The processing order change affects when your I-130 gets reviewed, not when you entered the visa queue. Does NVC or consular processing change? The processing order change applies specifically to USCIS adjudication of the I-130 petition. Once your I-130 is approved and your case moves to the National Visa Center or to a U.S. consulate abroad for visa processing, those stages follow their own timelines and procedures. The new USCIS processing order doesn't directly change what happens after your I-130 approval. Common myths versus facts. Myth: the new processing order means family preference cases will never get approved. Fact: all eligible cases will eventually be processed. Priority simply determines the order in which cases are reviewed. Myth: if I filed in 2024, my case will be sent to the back of the line. Fact: your place in line is based on your category and receipt date within that category. Cases don't move backward. Myth: I can upgrade my case to immediate relative status by paying extra fees. Fact: relationship category is determined by law based on your actual family relationship, not by fees or special requests. The phrase "must act now" can sound alarming. But let's talk about what reasonable action actually looks like in this context. First, if you're a U.S. citizen planning to petition for an immediate relative and you haven't filed yet, there's value in filing correctly and completely as soon as you're ready. Waiting doesn't offer any advantage, and filing sooner establishes your receipt date within the priority category. Second, if you're a lawful permanent resident and you're in the process of naturalizing to become a U.S. citizen, completing your naturalization could allow you to refile or upgrade pending petitions to immediate relative status, which would place them in the higher priority processing queue. Third, review your pending cases to ensure USCIS has your current contact information. If you've moved, file an AR-11 change of address and update your case online. Missing a request for evidence or interview notice because USCIS has the wrong address can cause significant delays that have nothing to do with processing order. Fourth, make absolutely certain that the I-130 you file or have filed includes all required evidence and supporting documentation. Incomplete petitions generate requests for evidence which restart the processing timeline and create unnecessary delays. Fifth, monitor your case status regularly through the USCIS online system. Set up case status alerts if available. Being aware of any changes or requests allows you to respond promptly. Sixth, consult with a qualified immigration attorney if you're uncertain about your category, eligibility, or how this change affects your specific situation. Immigration law is complex and professional guidance can prevent costly mistakes. What you should not do is panic, rush to file frivolous petitions, fall for scams promising to bypass the system, or make major life decisions based on rumors circulating on social media. Even under the new processing order, many delays are self-inflicted due to common errors petitioners make when filing I-130 petitions. Wrong category selection. Choosing the wrong relationship category on the form can trigger delays or denials. For example, if you're a U.S. citizen, petitioning your 22-year-old unmarried daughter, she's not an immediate relative. She's F1 preference. Filing in the wrong category wastes time. Incomplete evidence. Every I-130 requires proof of the qualifying relationship and proof of the petitioner's status. Missing marriage certificates, birth certificates, proof of citizenship, or proof of termination of previous marriages will result in a request for evidence. Gather all documents before filing. Outdated forms using an old version of Form I-130 can cause your petition to be rejected. Always download the most current form from the USCIS website and check the edition date before filing, ignoring USCIS notices. When USCIS sends you a notice, whether it's a request for evidence, a notice of interview, or a request for biometrics, you must respond within the deadline given. Missing deadlines can result in denial or abandonment of your case. Relying on social media rumors, immigration forums, and social media groups can be helpful for support, but they're also filled with misinformation. Don't make decisions about your case based on what someone posted in a Facebook group. Verify information through official USCIS sources or qualified legal professionals. Let's address some of the most common questions families have about this change. Will my case be denied because of the new processing order? No. Processing order determines when your case is reviewed, not whether it's approved. Your case will be approved or denied based on whether you meet the eligibility requirements, not based on what order it's processed in. Will approval be faster under the new system? For immediate relative cases, potentially yes, because they're prioritized. For family preference cases, it may take longer to reach the adjudication stage, but once reviewed, the decision process is the same. Does this affect interview scheduling? Interview scheduling happens after I-130 approval and is managed by the National Visa Center and consular posts. The USCIS processing order change primarily affects when your I-130 petition is adjudicated. Does country of origin matter for I-130 processing at USCIS? Country of origin doesn't affect processing order. However, country of origin can significantly affect visa availability for family preference cases due to per-country limits in the visa bulletin. Is this change permanent? USCIS policies can be updated or revised based on operational needs, legal requirements, or administrative priorities. While this is the confirmed policy for 2026, future administrations or agency leadership could modify the approach. Can I request expedited processing? USCIS does have expedite criteria for certain urgent humanitarian reasons or significant public benefit, but routine I-130 petitions don't typically qualify. The new processing order doesn't change expedite criteria. Let's take a step back and look at this change from a broader perspective. On the positive side, the new processing order brings more predictability and transparency to how USCIS handles family petitions. Families filing immediate relative cases can have greater confidence that their cases will be worked on systematically. The prioritization aligns with statutory priorities in immigration law that emphasize immediate family unity. From an efficiency standpoint, processing cases that can move quickly through the entire system first reduces overall backlog and administrative burden. It also means more families can reunite sooner rather than having cases spread across processing stages indefinitely. However, there are legitimate concerns as well. Families who have been waiting for years in family preference categories may feel frustrated that newer immediate relative cases are now being processed ahead of theirs. The change doesn't address the underlying problem of insufficient visa numbers and preference categories, which is a congressional issue, not a USCIS policy issue. Immigration attorneys and advocates have noted that while processing order changes can improve efficiency, they don't solve the fundamental challenges of an immigration system that has more demand than available pathways. Families in preference categories still face the same years-long or decades-long visa bulletin waits even after their I-130 is approved. The change also highlights the significant advantage of U.S. citizenship over lawful permanent residence when it comes to family immigration. Green card holders petitioning family members will consistently face longer timelines than U.S. citizens petitioning the same types of relatives. From a policy analysis perspective, this change represents USCIS working within its administrative authority to manage caseload more effectively. It's not a change in law and it doesn't create new visa categories or eliminate existing backlogs. It's a procedural adjustment to how the agency sequences its work for families navigating the system. The key takeaway is that understanding which category your case falls into is more important than ever. If there's one message to take away from everything we've discussed today, it's this. Stay informed, stay prepared, and don't panic. The change to I-130 processing order for 2026 is real. It's confirmed and it will affect how USCIS handles family immigration petitions. But it's not the end of family immigration. It's not a shutdown of the system and it's not a reason to make rash decisions. For families with immediate relative cases, this change may work to your advantage. For those in family preference categories, patience and careful case management remain essential. The immigration process has never been simple, and it's rarely fast. Changes like this remind us how important it is to file correctly. Respond promptly to any USCIS requests. Keep your contact information current and seek professional guidance when you're unsure. Remember that your case is part of a larger system that processes hundreds of thousands of family petitions every year. While it may feel impersonal at times, every case represents a real family hoping to be together. USCIS officers are working through these cases systematically, and understanding how the system works gives you the power to navigate it more effectively. If you found this information helpful, make sure to subscribe to stay updated on immigration news and policy changes that affect families like yours. Knowledge is your best tool in this process. Take care of your family, take care of your case, and remember that you're not alone in this journey. Millions of families have successfully navigated the system, and with the right information and preparation, you can too. Stay strong, stay informed, and we'll keep you updated as more information becomes available.